Thank you so much. And first, I'd like to thank the conference for asking me to participate in this project and even for remembering me. It was, at the turn of the century, I was last involved with you all working on matters of the Hague Securities Convention. And as you might expect, I listened with great interest to the many panelists speaking on this track, contributing substantive input to this discussion. What I thought I would do in my time is touch on a few points and then offer some thoughts on assessing the future life of the Hague Securities Convention. First, I'll state the obvious as background. We all know the Hague Securities Convention itself is a choice of law convention only and deals only with the law applicable to certain interests in respect of securities held with an intermediary. So its focus is quite, you could say, narrow. I'll also state the obvious that the primary rule, right, which is tied to a traditional lex re site concept via the qualifying office requirement, applies a healthy dose of party autonomy as well. This, not unsurprisingly, had led, as has been noted by others, to resistance, notably in Europe, to too much party autonomy. On the other hand, criticism in the United States, which has adopted the convention, has arisen to shackling our party autonomy rule with the qualifying office requirement, which, and I quote, took our platinum standard and turned it into gold. So there was unhappiness for certain aspects on each side. But let's leave that state of play where it is for a moment and turn to the emergence of digital assets, of which there are many kinds, which has been noted, and will be many more, some native to the digital, distributed ledger world, and others not. And we have to keep in the back of our minds as we talk about choice of law rules that digital assets, those that purport to represent or are tethered to real world assets, are going to implicate substantive law rules that will be involved in determining whether what you do with that digital asset has an effect, and if so, what, on the underlying real world asset, which is different from natively crypto assets such as, let's say, Bitcoin, which is always the easy example. Many commentators, right, including those participating in this conference, as well as those involved in the Financial Markets Law Committee 2018 report on distributed ledger technology and governing law rules, have been very vocal about the poor fit, shall we say, of lex re site concepts in this space. The FMLC itself supported a concept, not unfettered, of elective situs to govern certain aspects of the digital world. Many commentators have also noted that party autonomy can be at odds with legitimate regulatory concerns. This is, became quickly apparent in the space of intermediated securities, many of which are held, in fact, by highly regulated entities. Let's also note there's an obvious lacuna of regulation in the digital asset space, but it will come, and we see it happening in many, many jurisdictions now. Finally, as Professor Michaela noted in her remarks, the early promise or threat of disruption or disintermediation of the securities markets by distributed ledger technology has in fact led to the consternation or amazement, depending on which side you're on, of some, to the evolution or reversion to more and more intermediation, which I think was not initially expected. In fact, we are all aware of the merge of Ethereum, right? And the move to proof of stake work may itself accelerate this move to intermediation, because people want more and more services associated with their digital assets, and many have concerns about the responsibility of taking care of their own private keys, etc., in this space. And we've certainly read a lot about people losing assets, which is unfortunate. So now, if you will indulge me, I'm just going to have a little digression about what's been happening in the US, and then I'll attempt to pull some threads of what I'm saying together. So, an explosion of digital asset, principally crypto trading, led to market behavior as if commercial law provided a solid basis for this behavior, right? Most notably, people relying on the good old possession is 9/10 of the law. Don't you love the reference to possession in this case? But as many of us are undoubtedly aware, the other 1/10 can kill you. The concept that if it's in my wallet and I've got the private key, I'm safe, does not really reflect what's going on in this space, at least in the commercial law where we practice in the United States. Recent SEC accounting staff guidance, or shall we say dictates, prompted some unfortunate disclosure that many of you may be aware of, that Coinbase put out, and some recent bankruptcies as well have really highlighted the uncertainty in terms of whose assets are these things when they're held through a custodian. I won't even use the term intermediary yet. Very basic concepts of whose property is it. And of course, the law applicable to this, answering this question, is very unclear. As a partial solution to concerns about risk of loss and the delayed state of commercial law development here, participants, many in the United States, turned to the warm embrace of UCC Article 8 and its concept of treating almost anything as a financial asset held with a securities intermediary, thus affording certainty of rules governing various acquisitions, dispositions, including pledges, protection in case of custodial insolvency, and clear governing law rules. Of course, this solution only addresses digital assets once they are in the intermediated system. Getting them in there, knowing how they can be transferred as a commercial law matter and as a governing law matter was still, not addressed. We're just talking about essentially the Part 5 rules in Article 8 of the UCC, which one needs to analyze through those duties that apply to a securities intermediary, whether, in the terms of our commentary, whether it makes sense to apply rules of intermediation to digital assets. For example, there are different ways in which wallets can be established. There are different levels of involvement of the entity acting as a custodian versus the entity purporting to be the customer. Is that access shared? Who, using loosely the term control, who controls those assets? So these issues are not answered by the UCC. Of course, the UCC addresses once you've already determined that it makes sense to allow an asset to be treated as a financial asset and thus handled within the indirect holding system. But again, the direct holding is not addressed by the UCC, and in any event, the UCC only addresses direct holding of securities. And as you know, there's a lot of talk about whether certain digital assets are securities in the first place, but many, of course, are not. In any event, recent very fast-tracked UCC changes including a new Article 12 dealing with certain types of digital assets. These new rules were promulgated in a form that's now ready for state adoption. The promulgating organizations, the American Law Institute and the Uniform Laws Commission, had 2 readings over the past 2 years, and this past July finalized these rules. The commentary, like the commentary to The Hague, is a little slower. It won't take very long. We're going to get the commentary out this fall. But that's not official anyway, and states who adopt the statute will not necessarily adopt the commentary, but of course we all need it as practitioners. Many states, as you may be aware, have started jumping the gun in terms of treatment of digital assets in the United States. Wyoming is always pointed out. I believe Texas adopted a prior draft of part of new Article 12 of the Uniform Commercial Code, but promises to adopt the final one in due course. In any event, these new rules in Article 12 govern certain aspects of acquisitions and dispositions. Associated amendments to other articles address pledges of certain digital assets in their native state. This does not disrupt in any way the treatment of digital assets in the indirect holding system if they come in to be treated as financial assets. Article 12 really addresses the assets in the sense of being held directly. And in that connection, the new article includes a set of choice of law rules, and it will not surprise you to hear they are party autonomy heavy. There is a waterfall, and it starts with the terms of the record. And let me just take one tiny step back. In trying to come up with these new rules, including these choice of law rules, the drafters were trying to be extremely tech neutral. We don't know what's going to be developed out there. We don't really know all the protocols. Obviously, we don't know how they work, their internal mechanisms. So the terminology for the digital assets that new Article 12 is addressing, the terminology is controllable electronic record. So it's a record, any kind of record that's electronic, very broadly defined, that's controllable, which means subject to control in the definitional way the UCC now offers up, which is essentially the ability to derive the benefits of the asset, to control the transfer of the asset, and to prevent others from having the benefits of that asset. It's a very functional, people who worked on The Hague will remember that word, very functional approach. And the waterfall is that you start by looking at the record, and we know that these digital assets can, many of them probably don't, but can have all sorts of information in the record and could, if they wanted, have a choice of law rule that says, this is my controllable electronic records jurisdiction. And if that is in the record, that will determine the applicable law, the law applicable to the issues covered by Article 12. Failing that, if the rules of the system have that sort of selection, then that's the applicable law. Failing that, if the record itself has a governing law provision. Now, of course, something like Bitcoin, I'm presuming, we were all presuming, does not, but in any event, then failing that, if the rules of the system have a governing law. Failing all of that, and keeping in mind that we know this is really operative only in the United States, failing all that, there's a drop down to the District of Columbia as if it had adopted Article 12, new Article 12 of the UCC. This is reminiscent for some of you of what the Treasury Department did when they were updating the choice of law rules for U.S. Treasury securities. They deferred to state law as if it had the state in question had already adopted the new revised then Article 8 of the UCC and its choice of law rules. So in any event, that's our internal way to help provide a landing pad for the choice of law analysis in this space. So, sorry, back to the Hague Securities Convention. Let's take a just look for a minute on what might make it more attractive and useful in the coming years. The first stop would be, I think, to take a look at the definition of securities held with an intermediary to see if it's already broad enough or can be tweaked to be broad enough to accommodate at least some of the digital assets that are out there. Again, I think it probably will be a challenge to think of the choice of law analysis as it applies to natively digital assets versus those types of digital assets that will, as I said earlier, purport to represent or be tethered to an underlying asset. Just as a basic example, we have some digital assets in the United States that we think operate very much like electronic documents of title, right? They purport to evidence rights in, say, gold or underlying commodities. Those are very, very different animals, I think, including for choice of law rules, than, say, cryptocurrency. In any event, we probably remember the explanatory report, which is very useful for the Hague Securities Convention, and it has commentary, of course, about securities held with an intermediary, and the language in there, makes very clear that the intention was to be very broad, anything that's financial in nature, and certainly I think many people will agree that many digital assets are financial in nature. It points out that the manner of issuance of the asset is immaterial, and that's very helpful when we're trying to see if there's a way to mesh these spaces. It, of course, excludes cash, meaning money and deposit accounts. So things like central bank digital currencies and so forth, I imagine, are clearly going to be excluded. But let's see if there's enough flexibility there to be sure that at least insofar as things are intermediated, the Hague Securities Convention scope will pick them up. Then maybe we could take a fresh look at the primary rule and maybe see if it could use an elective situs approach that more directly acknowledges the role of regulatory limitations. Maybe the qualifying office isn't necessary, just my view, but maybe something that more directly expresses what I think was implicit, which is if there's a regulatory body saying, for example, in the United States, that Depository Trust Company, our major depository entity, that we know that their rules, they are regulated by the SEC, their rules have to be approved by the SEC. So aside from its own self-interest, the regulators would never approve DTC saying that Goldman Sachs's account is governed by New York law, but JP Morgan's account is governed by Texas law. They just wouldn't allow it. It wasn't necessary, and it wasn't necessary to say it. But maybe we should take a fresh look as to whether a more express recognition of regulatory limitations would be appropriate and would make the party autonomy more palatable. And then third, even more ambitious maybe, and this is my last thought, and I'm sorry I'm not taking up your full 30 minutes here, but even more ambitious, maybe let's see if the convention itself or maybe a companion act could offer up a type of elective situs as a choice of law rule for certain issues in relation to certain types of digital assets when they're held directly. This, as I spent a moment or two talking about, is what we have just done in the United States. We have our rules for intermediated assets in Article 8, those held with an intermediary. And then we have new rules for digital assets held directly, so that you know if you are a buyer or a seller. No, if you're a buyer or a seller, a pledgor or a pledgee, third-party creditor, and so forth, you know where to look for whether you can how you can acquire rights in those assets, and whether you acquire them in a way that the market thinks you do, meaning free of adverse claims. And just like if you had regular money or a negotiable instrument, the acquisition of rights free of adverse claims in a way that these assets have already been perceived by some. The choice of law rules for that, which track very similarly to what we tried to do in UCC Article 8, were brought to bear in the direct holding of digital asset space. Whether that can be married with an existing Hague Securities, the existing Hague Securities Convention, or whether it would have to be a companion act, I don't know, but hopefully they will talk to each other and be an integrated system. And that shouldn't take long. Anyway, that's the end of my remarks.